the request for reasons. There isn't as yet a button on e-filing, despite our numerous requests of SARS to put such a button on, because that will assist us all in tracking the reasons and making sure that they are followed up. If you have an audit, you will have the name and email address of the auditor in general, and that is the person to whom you will do your request for reasons. It falls outside of the e-filing system and it's not properly monitored. If you have an assessment that has been raised where you are needing to know why, so for instance, we have received an assessment recently with a whole lot of additional interest on that assessment, and the taxpayer does not know where that interest came from, or so they say. So we're requesting reasons as to what is the reason for that additional amount of interest, what is the bank account number, and why did you bring that in to account on our taxpayer. And in that case, what we are doing is we're taking it down by hand to the SARS office, addressed to the branch manager, and then we are uploading it onto the PCC on one of those various channels as a second, but we have proof that we have lodged that with SARS. The key issue on the request for reasons is that it suspends the objection process, so you must have clear proof that you have made that request for reasons, because you only need to lodge the objection 30 days after receiving the answer to your request for reasons. Now, reasons are very important. You need to know why SARS made the determination that they did, so that you either understand it and can object to it, or you can come to that golden moment where you actually agree that they are right in what they did, now that you understand why they did what they did. And this is a hard-fought issue that were challenges in court to make sure that we could get the reasons. This flows from one of the key issues in our Constitution, the right for administrative reasons. So we need to make sure that we are beginning the process of requesting reasons. It would be a letter to SARS headed up as a request for reasons in terms of Rule 3 of the objection and appeal process. And what we need to look at, as the new rules may take the shape they are proposing, it's going to be very important for us to have the necessary reasons. And also, from the point of view that you are dealing with the assessor who actually raised that assessment, that's the closest you're going to get to the truth as to what was in the mind of the commissioner when that assessment was raised. Later, various attorneys and advocates are going to get involved on SAR's side and put various arguments as to why that assessment was raised. But it's nice to have that anchor as to what they said at the contemporaneous time, not 5 years later, was the reason for the assessment. So when there are key issues on additional tax, on penalties, on various amounts, you need to know the why that SARS was thinking at the time in order to be able to properly deal with it in the objection process. Now, the late objections that are plaguing many of our officers. You've got the 30 days to lodge the objection, and if you are going to be late, then later than the 30 business days from the process date, you need to be asking SARS in advance for an extension in order to make your life easier. It's not a requirement, but if you know that you're going to be late and your systems are in place now, but you're waiting for certain documentation, it will be far easier if you request an extension of time rather than having to go through the various processes that flow thereafter. And if you do not do the request for extension, then you are going to need to motivate clearly in the objection why you are late. Yes, sir, at the back.
That's all very well in theory, but who is the senior SARS official?
Okay,
where those guys not officially being appointed.
Well, the question for the webinar people is, who is a senior SARS official? Yes, they haven't been circulated to us, but internally they have been appointed. Your branch manager will certainly be a senior SARS official. We won't know the rest of them until we have their listing, but at the very least, the branch manager is a senior SARS official. Now, if you are, and if you're not going to do it by way of an application for an extension, you're going to do it later in the objection, you'll need to cover it in the objection process why you are late in lodging the objection. Yes, at the back and from the webinar.
Tracy Jones from the webinar asks, after you request for reasons, how long does SARS have to reply?
Okay, so after you request for reasons, how long has SARS got to reply? We will look at the time frames later when we get to the end. SARS has a defined time frame. It's about 60 days for them to deal with the request for reasons. They can get the extension, it's 30 and then an additional 60. They generally aren't sticking to their time frames, and the issue of the non-compliance with time frames I'll deal with at length under Rule 26 and the processes related to that. So now you are lodging your objection, and you're lodging your objection late. You never made a request for an extension of time, maybe because your office is still working on the wrong datings of these things. Now you need to give comprehensive reasons why you are late in order for SARS to get you into the game. The later you are in the process, the more reasoning you're going to need to give, the more they're going to focus on the prospects of success in your matter, that you are more likely to succeed than not when the objection is ultimately dealt with, and any other factors that SARS would need to consider. And you can't just use ignorance of the rules, and you can't just blame your busy office for the delays in lodging the objection. You are going to need to go broader than that. And this, unfortunately, is going to be a key fighting point with SARS, because they are being stubborn on fixing the fixed date of the lodging of the objection and the adherence to the additional 21 days with just a reasonable ground, and the later period requiring extenuating and exceptional circumstances. And we are all grumpy at their non-adherence to the time frames, and I'll deal with methodologies to unleash your grumpiness later, but they are going to adhere to the strict letter of the law. That's what the law is. Those are the time frames that the law has, and we need to make sure that we are getting our officers into that system. The further you are in a delay period, the more you're going to have to show the hows and the whys in order to get into the game even of having your objection looked at. And one of the key issues, and SARS have been to court with this many years ago, when you are requesting an extension of time, so you're in the additional 21 days, or you after the 21 days into the 3-year period, you need to show the merits of success. That's going to be a key factor. The merits of success will need to be set out very clearly, because that will be a factor to even bring you into the game. So you've got your 30 business days from the process date to lodge the objection, which gets delayed by 30 business days from the receipt of the reasons, should you request reasons as part of the process. Then you get an additional 21 days, and all you have to show is reasonable grounds, and then all the way up to 3 years, but you have to show exceptional circumstances, and that is the difficulty that we all have. And in the appeal process, it's much tighter. It's your 30 days, 30 business days from the notice of disallowance. Then you get the additional 21 reasonable grounds, and then you get an additional 45, once again, exceptional circumstances. Now, if we are lodging our objections late and our appeals late, our taxpayers will have some issue with us, especially if the delays have been in our instance. And that's part of the reason why I hold the view we must bring them into the knowledge of that objection process, so that they are our partners in that process, and that we don't have nasty fingers pointed at us that we are the ones that are late. Because there will be ramifications. There will be financial ramifications when they seek compensation and damages because the objection has not been dealt with, because SARS won't allow it onto the objection roll. Or there will be reports of us to our professional bodies for not maintaining the professionalism that we need to in the objection and appeal process. The time frames for the appeal is much shorter than the time frames from the objection, because there should just be a crispening of what you have objected to and how SARS have dealt with the matter in the notice of disallowance. In truth, all you need to say in the appeal is that we appeal against the disallowance of our objection dated so-and-so, and we rely on all the grounds set out in our notice of objection dated so-and-so. That's all you have to do to stay in the game. Yes, it's nice to deal with the issues that were raised in the notice of disallowance and to give further argument in support of the underlying reasons and causes that you gave in the objection. But if needs be, in order to get the matter lodged timeously, that is the minimum that you need to do to bring the appeal in. So one shouldn't be in lodging the appeal. Maybe one will have some issues on the lodging of objections in complex matters when one has to go back and get documents and meet with the taxpayer a number of times. That's the more difficult one to deal with. But the appeal, one should be able to lodge that on a timeous basis. Now, the exceptional circumstances is a difficult one. It's been all the way up to the Constitutional Court on various matters, and there isn't a defined reading and ruling as to what this means. If you can put it in a list, then it's no longer exceptional, and that makes our life far more difficult. So in truth, we really have 30 days plus 21 days, and anything more than that, we are starting to ask for some trouble along the way. Now, parallel to the process of objection and appeal is the request for suspension. Now, SARS has a number of issues that they are meant to give consideration to when you make a request for suspension. They are meant to look at your compliance history is but one of the aspects that they're meant to look at. They're meant to look at a whole lot of other issues. Unfortunately, the reality of the matter is that their key main focus is going to be on your compliance history and not necessarily of the tax type that you are in dispute. So we have a matter where we are disputing PAYE, but we have a 2012 income tax return outstanding because the taxpayer went through a grueling audit of 5 years, has changed accountants, has got significant processing problems, and we haven't been able to lodge the 2012 return. It's got no bearing on the PAYE matter. It's got no bearing on the impact that the recovery of the PAYE matter will have on the taxpayer. It's got no bearing on whether we can give any security and our prospects of success in the PAYE matter, but we will not get an extension and suspension of payment because we have a compliance history problem. So this is a key thing. What one needs to do, as we have done in that case, is to detail up front where your compliance history problem is and why it is, so that when at first you're told no, you have the ability to go higher up the chain of command of SARS, or take it on review, or take it to the Ombud if they are clearly looking at something that is not relevant to the decision-making process on the suspension of payment. But this is an important document to send into SARS. Now, if your assessment arose from an audit, there will generally be a final audit letter, and that letter will not only tell you how you must lodge your objection, but it will also tell you who has been assigned to your file in respect of collections management. In that case, you'll address correspondence to that person. In other cases, you'll need to address it to the head of collections, debt maintenance, debt recovery at the various offices. I know that this is one of the things that we in Durban have right. We were the voortrekkers in Siaka, so we were the voortrekkers in not being able to talk to people, but have to do things remotely. So we have fought hard for lists of who the relevant people are at SARS, the branch manager, the collection manager, the audit company manager, the audit individual manager, and when you lodge objections, who you must lodge them to and who the follow-up people are. I know that site is going round to the various revenue offices and working hard and making sure that these lists are available, and you'll need to work together with site to make sure that these lists are available in your area. But that would be the person to whom you would be making that request for suspension. Now, as long as you've got clear proof that that letter has gone to somebody of a competent nature, this is the one letter that you don't want an urgent reply to, because until they say no and until they count to 10, they can't do recovery action, or so it is in the perfect world. We've got one where they only managed to count to 9, they couldn't count to 10, and began recovery action, taking 15 million rand out of our client's bank account. In the end, they capitulated completely. The assessment was withdrawn, but we are still fighting for our interests. But in general terms, once they say no, they must be dignified and wait till they count to 10 business days, and only thereafter can they begin their recovery action. So that's the one you don't want a prompt reply in case it's a no. Now, one of the key aspects that we're fought hard for in the Constitutional Court when fighting the pay now, argue later principle is that that principle stands, but there is the exception that they must give consideration to what that payment is going to do to the taxpayer. That once you win the war and the assessment is reversed, are you going to be so devastated that your business cannot continue? And in those cases, they must grant you the suspension of payment. Now, this has been hard fought. Initially, it was in the Income Tax Act at the end in terms of Section 88, and now it's been brought into the Tax Administration Act, and later we'll look at the key and specific section in that regard. But it is an important right that has been fought for the suspension of payment pending the objection and appeal process, and one must make sure that one is using that right correctly. Now, if you do not get suspension of payment, then interest should be paid on the amounts that have been taken in terms of the pay now, argue later. They say that it is an automated process, but I can assure you that we have an example where it was not done in an automated process, and we have still many months later not received interest. So you need to make sure that if you are successful, that you are following up with a request for interest, because it should have been paid to you. And if you don't do your suspension of payment correctly, and even if you used to have some significant friends, you can have a problem. And even if you used to murder a few people on the side, you can have a problem. So it's important to make sure that you do those requests for suspensions, because the powers of SARS are great. They will get you to the state of an insolvent far quicker than you in a commercial matter would even have had your first hearing. Now you've lost your objection, you've had your notice of disallowance, and now you need to lodge your appeal. You've got 30 days from the date of the disallowance, 30 business days. You've got the additional 21 and then the additional 45, but only on exceptional circumstances. And yes, you're going to appeal the matter. You'll generally start off at ADR, and if it's below 500,000, you might go to tax board, and if it's below 500,000, you might ultimately go to tax court. But for most of us, we hope we resolve these matters either at the objection, or latest the appeal, or the very latest in the ADR process. That is still the realm where we as accountants can go and debate an issue with SARS. In the old days, it was called a meeting with the assessor. Now it's called an ADR process, a little bit more formal. I remember going up for a final meeting before we were going to court, with Advocate Brumberg, and it was a long outstanding matter with SARS, and the whole way from Johannesburg to Pretoria, I acted for SARS, and I put up a strong argument for an hour in the car. And then when we get there, we have tea for 5 minutes, and 3 minutes later we're shaking hands and packing up and going home, and SARS are just conceded. And that's part of the reason why they've moved away from just the meeting. They need the controls in the process. It doesn't mean that that decision was a wrong decision, but I certainly gave it an hour's worth of fight against Brumberg. They gave it 5 minutes and capitulated. So that's where the ADR process is, to try to make sure that there's some balance in the process, but at least it is a cost-effective mechanism of resolution. We'll look at that in a bit more detail. So the ADR process is, in terms of the rules, yes sir, at the back?
The exceptional circumstances rule, does it not apply to the appeal process?
Yes, this exceptional circumstances rule is the 45 days is the exceptional circumstances in the appeal process, and the more than the 22 days to 3 years in the objection process. So both of them have an exceptional circumstances extension. But hopefully for the appeal you shouldn't need to get to that stage.
So if you're out of 45 days,
then that's it. If you're outside of the 45 days and you haven't lodged your appeal, then the matter is closed. We'll look at one last aspect that you might be able to raise it under, but in general the matter is closed if you can't get in, and that's where the risk for the professional is. If you can't get into the exceptional circumstances case, you can't get in to play the game, then the taxpayer's rights to object and appeal have been compromised by your delays, and that's when issues will start arising. So the